Chair. I would like to talk about Clause 8, Sub 3. Now, this is in relation to when legal aid may be granted in criminal matters, and it says when determining whether an applicant has sufficient means to enable him or her to obtain legal aid, you basically have to go to Schedule 1. There's a couple of questions I have, and one of them is if you go to Schedule 1, Clause 4, Sub 4, it says where an applicant for legal aid for a civil matter is made by a minor aged 16 years or over, the Commissioner may treat the resources of the following persons as the resources of the applicant. Any person who under any agreement or court order is liable wholly or partially to maintain the applicant, or any parent, foster parent or step-parent with whom the applicant is living. Now I wonder, Mr. Chair, if in fact, let me give you a hypothetical example, a university student committed an offence, went before the courts, whether the parent's income actually means that the student is not liable for legal aid. It's just one thing here, because I know sometimes students do silly things. The last thing they want is their parents to know what they've done, but in fact this may fall under this. But if you have a look at the definitions in Schedule 1 around when you can and cannot have legal aid, I'd like to go to Part 2, meaning of income. In relation to an applicant for legal aid, income means the person's total gross income during the 12 months immediately before the application for legal aid. Now, I'm not too sure where the income level sits, but if you understand that 75% of New Zealanders earn under the average wage, I'm assuming that probably around 75% of New Zealanders are liable for legal aid because they would probably come underneath that total gross income test. But if you go again, Schedule 1, Clause 2, Part C, Subpart 3, it does include a benefit. So if a person is on any sort of benefit, then that's included in the income test, except if the person is receiving an orphan's benefit, an unsupported child's benefit, a child disability allowance, an emergency benefit payment, or an accommodation supplement. And again, I'm wondering, for example, these dreadful people we're seeing in Christchurch who are doing all this looting, etc., if they're on an emergency benefit, will they still be eligible for legal aid if they're earning above the income threshold that's set here? There's just a couple of anomalies I wouldn't mind answering. Also, if you receive a special benefit or a disability allowance, that is not counted in your income for that year when determining whether you're eligible for legal aid. Now, under Schedule 1 again, if we go to Clause 3, it talks about meaning of disposable capital. Again, in relation to an applicant for legal aid, disposable capital means that a person's total assets after deducting the amount of any debt secured against those assets and after deducting the interest that a person has in a home and equity and this sort of carry on. And again, I'm assuming that this is the test that the ex-company director of the failed finance company used when he put forward, when this person's lawyer put forward an application for legal aid, which was turned down. I suspect if that hadn't been turned down, there would have been such a hue and cry that there, in fact, may have been revolts in the street, so it wasn't a bad outcome. But the thing that's also interesting is that the resources of a spouse or partner, or parents of a minor, which I talked about, but the resources of a spouse or partner, this is Clause 4 of Schedule 1, are also counted in determining whether a person is eligible for legal aid. And I quote, any resources of a person's spouse or partner must be treated as that person's resources unless the person is living apart from his or her spouse or partner, or the person and his or her spouse or partner have contrary interests in the matter. Now, spouse or partner, I'm assuming again when we talk about partner, we're talking about a legal definition of partner as, I don't know, in the Matrimonial Properties Act or something, so I'm assuming you've got to be together for more than 2 years. It would be dreadful, for example, if someone had hitched up, they'd moved in together, and then 2 months later, after being together for 3 months, this person was up before the courts and they couldn't get legal aid because it was determined that their partner, in fact, earned above the income threshold. So I'm just quite curious about the test of a partner there. We all know what a spouse is, Mr. Chair, because that assumes marriage, but a partner, I'm just a little bit unaware where that test would kick in. If you look at here as a minor...